I'm Michael Ettinger from Ettinger Law Firm, a New York elder law estate planning firm.
I'm Suzanne Ettinger of Ettinger Law Firm. We practice elder law estate planning.
I've been practicing since 1980. That's going to be 38 years.
And I've been an attorney since 1993.
We have actually 15 offices throughout New York State, from Saratoga Springs and Albany, that's the capital district. We have 3 offices in the Hudson Valley, Rhinebeck, Middletown, and Fishkill. We have offices in White Plains and Westchester County, in Nyack and Rockland County. We have 3 offices in New York City and 5 offices across Long Island.
Some clients come in and say that they're too young to do an estate plan, but it's important for everyone to have some sort of plan in place.
A lot of people think estate planning is for the wealthy, and it's a misconception. Actually, estate planning has nothing to do with having an estate. It's sort of a misnomer. Your estate is actually whatever assets you have, and you really want to get those assets to the people you want, when you want, the way you want, with the least amount of taxes and legal fees possible.
Well, people come in all the time and they're afraid that it's too expensive. But what we do is we do an analysis of what they need, and they have to determine whether it's worthwhile for them. By doing a proper estate plan, they end up saving money in the long run.
That's true. Most estate plans either save the client money or make the client money. For example, if you don't have to go to court to settle the estate because you have a trust, you're actually going to end up saving a lot more than the cost of setting up the trust. A lot of people are afraid of lawyers, and maybe that's because what they see on television.
I tell people that I've dubbed us unlawyers because the way that we practice is not typical. The standard is when an estate plan is done, the lawyers release the client. They really don't have much to do with them anymore. But in our practice, we continue the relationship, so they're comfortable when and if something happens. Their family can come to us, they know us. It works much better that way. So
maybe we should let people know what actually happens in the estate planning process. Like, what happens when you go in and see somebody for an estate plan, at least at our firm?
Yeah, I mean, it's important that we let people know that what we do is we really get to know the client and their family. We always say the family dynamic's the most important thing in planning. So we have a long interview with them. It's a little bit of a therapy session, in most cases. Get to know what their assets are, what their plans are, whether they have estranged family members, all important elements in determining what plan is right for them.
Son-in-laws, daughter-in-laws, do they like them, they don't like them, that sort of thing. We're trying to find the family dynamic. And so it's really very low-key, it's very relaxed, because the clients are just coming in and talking to us, like sitting around their living room and having a chat and getting to know the family from their point of view. And the first meeting is just get to know each other. So we don't really do business. We're, seeing if we're a right fit for each other. So it's very comfortable, I think, for people, don't you?
I do, and they're also gathering information. A lot of times people come in and they don't know anything about the topic. Either they've come to our seminar and they have a base, or they're just coming in cold. So it's not only getting to know us, but it's gathering the information to see what's right for them and developing a relationship.
Yeah, I think one of the things that we do is we go purposely slowly. We let people absorb the advice we've given them. We ask them to go home and think about it, and then they can come back a few weeks later and there's still no obligation. We're going to answer their questions, and we'll talk further about the estate plan. We'll draft it. We'll give them a written proposal. The client is really a free agent and is always in the driver's seat. I think one of the things we do that's different is we make sure the client's always in control of the situation. And one of the ways we do that is we don't actually take any legal fees until it's all done, which is very unusual. And actually, until the client writes that check, they don't owe the firm anything. So they're always in the driver's seat. So they're always in control, and they always feel comfortable that they're not getting into something, over their head, or something they don't want, or something they don't understand.
I think that goes over very big with people. People are a little bit surprised when I tell them we don't take legal fees until you're satisfied. We do all the work first. But it works better. I tell them it works better for us and it works better for them because they are in control.
Yeah, and then once they sign with us, we don't say goodbye. We say hello. We undertake to track their plans, all their legal documents for law changes, so they never have to worry if their documents are going to be out of date. We also call them in once every 3 years for a free review to see if there's any changes in their personal lives. Health, assets, births, deaths, marriage, divorces, so that when they get an Ettinger plan, they know it's going to work when they need it, not when they wrote it. It could have been decades earlier.
The first pillar of estate planning is protecting yourself if you become disabled. Having a plan in place so that you're not at risk for a court proceeding, a guardianship proceeding, so that a judge cannot appoint who would be in charge of you if you became incapacitated or disabled. You want to pick your family, close friend if you don't have family. So you need to do disability planning. That's a very important pillar of estate planning.
So one of the pillars is disability planning. I think people are unaware that due to advances in medical science and better health and nutrition, with people living so much longer, actually an average of 32 years longer than did a century ago, today about half of all people are going to have a period in their lifetimes where they can't handle their affairs. Of course, usually later in life. And not everyone is aware, if you don't have a plan, the state has written a plan for you, which you mentioned, called guardianship proceedings, but the state can appoint a stranger to handle your affairs. If you have an estate plan with a trust, it prevents the state from appointing a guardian because a trust trumps a guardianship. So if you have a trust, they can't appoint a legal guardian and you're going to get the people that you choose. And maybe you can explain, why that's so important to have your people in charge.
Well, of course, if you become disabled or incapacitated, you want your own people to be able to take over, take care of you, make sure that you're getting the right and proper care and your finances are being handled. If the state appoints someone, it's usually an attorney. And that attorney can only spend the money on you. And if you get better and you want to take back control, you need to go to court. Oftentimes you need to start a trial, make a motion, and the attorney may oppose your motion because it's the end of his payday. So you want to have your own family in place taking care of your affairs.
Right, and what happens if you have your own family, what are they going to do if you become disabled? They're going to go see your elder law estate planning attorney, and they're going to find out there are a number of options to protect your assets from long-term care, from the state making you spend everything. But the options are only available if your family's in charge. Because your family can move assets, they can make gifts, they can shift assets. But once a legal guardian is appointed, they can only spend the money on the person they're guardian for. You basically have the state's plan, spend it on you till there's nothing left.
So what is the second pillar?
The second pillar of estate planning is avoiding court proceedings on death. And that's called probate, and wills have to go through a legal proceeding called probate. And the problem with probate, and it took me a long time to really come to the ultimate problem with probate, and the ultimate problem is not just the court proceeding, it's the loss of control. When you go to court, you're not in charge, your lawyer's not even in charge. The judge is in charge. And having been a litigator for 11 years in my previous career, I found that the judge doesn't always act in your best interest. And the judge can make a mistake. And who wants to be in a position where when somebody says jump, you have to say how high? And that's what you have to do in the courtroom. So what we're about, I think, at Ettinger Law Firm is giving people back control. If you don't have to go to court, your family's in charge. They're going to act in your best interests. They don't have any other interests to consider. If they make a mistake, well, I'd rather my loved ones, the people I love and trust, make a mistake than a stranger make a mistake. But I'm going to reduce my chances of a mistake against my own interest. And I have control. And when you have control, you save time and you save money. And you also have privacy. In court, everybody knows your business. If you stay out of court, nobody knows how much you have, who you left it to, who you left out, except the people named in your estate plan.
Another thing about probate, I always say this is my favorite thing about probate. The fact that probate was developed over 500 years ago, we still use it today. Yeah. And who developed probate?
Well, it was Henry VIII, actually. And he developed probate because he figured out that if he made his subjects go to the courthouse, when somebody died, he'd be able to collect the king's ransom, currently known as the IRS.
The third pillar of estate planning. You want to come up with a way to keep your assets in your family, protect them, make sure that they travel through the bloodline as opposed to going to in-laws, creditors, divorces. So by doing an inheritance trust, which we do, we make sure that the money that you want to leave to your heirs gets to them. While it's in their trust, they're their own trustee. They can take the money and use it however they wish. However, it's protected if they get sued, declare bankruptcy, if there's a divorce, that money is safe. And then someday when they die, whatever's left does not go to their spouse, it goes to your grandchildren or to siblings or nieces and nephews. It allows the money to stay in the family for generations to come. These trusts are extremely popular. We've done well over 10,000 of them.
So with the inheritance trust, what you're saying is Johnny, we'll call him, the son, gets the money in the Johnny trust. He's in charge, he can do whatever he wants. Could spend the whole thing because you don't want to rule from the grave. But the trust says, Johnny, if you get divorced, your spouse can't touch it. If you get sued, creditors can't touch it. And when you die, we'll call him Johnny Jones, okay? The Jones family money doesn't go to his spouse, who can get remarried and share with a complete stranger. Instead, the Jones family money will go to Johnny's children, our client's grandchildren, and it stays in the blood. So instead of the will, which stops at death, that inheritance trust goes 30, 40, 50 years after the client dies, protects the inheritance from divorces, lawsuits, and creditors that pass by blood instead of by marriage.
And the fourth pillar, which some people feel is the most important pillar, wills don't do anything to protect your assets against the extraordinarily high cost of a nursing home. If you do a trust, you're able to protect your assets by using the vehicle of the irrevocable Medicaid Asset Protection Trust. Why don't you talk a little bit about that?
You're touching on a good point. Nursing home costs in New York are running now, on average, $15,000 to $18,000 a month, at least in the areas where we practice. And you're responsible for the first 5 years, which is adding up to about $1 million. So we like to say you better have a plan to deal with that before you worry who's going to get it after you're gone. There may be nothing left. So asset protection with a Medicaid Asset Protection Trust is the fourth pillar. That's the famous trust. You set up 5 years at a time, protects your home and life savings. When we sit down with a client, we actually take the time to explain the trust to them. We always send them home with a copy of our book on elder law estate planning, and we ask them to read the chapters about Medicaid trusts. It might be an hour's worth of reading. Mark up the book, come back, ask their questions, have their questions answered. And when they understand it completely, they're very comfortable because it is quite flexible. They feel confident to proceed. So actually, what we do is we build the client's confidence because, as I've said before, if you don't understand your plan, you don't have a plan. So make sure the client understands the plan. They go confidently into the future. They know exactly what's going to happen, no matter what comes their way.
If you use a will as your estate plan, there's court involved when you pass. Your assets can't pass freely to your heirs without going to court and going in front of a judge. You don't know what judge you're going to get. You don't know his schedule. You don't know the vacation schedule. It could take, the average probate in New York takes 1 year. So if your estate has to wait a year before, let's say, the property can be sold, there are taxes due, repairs and improvements may need to be made on that property. If you have a will, that money has to be paid, and that comes out of the estate, the money you would have rather seen go to your heirs. Well, one of the reasons we want to avoid wills.
Yeah, so people might need the money and not be able to get at it. People think, will is an estate plan, but because the will only starts at death, there's no plan for disability. We said before, if there's no plan for disability, well, there might be nothing left by the time the will comes around. I like to use that old analogy. They used to say the operation was a success.
But the patient died.
But the patient died. I say that about wills. We had an excellent estate plan, except there was no estate left. So, no plan for disability, and as we've learned now, going into our 28th year, and we explain this in our public seminars all the time, planning for disability has become more important than planning for death, which is why the will is obsolete. It's only a death plan, but planning for disability is for the client, and it's their home and life savings, and unless it's sheltered, as I said, maybe nothing left.
Another thing about wills is the privacy issue. Any will that goes through probate becomes a public document, as you know. So anyone can go to the courthouse and see what you had, who you left it to, what they got. That's why, you know, when a celebrity dies, we know exactly what he or she had, but it's true of all of us. It really doesn't make sense in this day and age to use a will. That privacy issue is a big issue.
So with the trust, because it's not in court, nobody actually knows how much you had, who you left it to, who you left out, except the people named in the trust, the only people's business it is. The other issue about will planning is it's a lot more expensive than setting up a trust, because when someone dies with a will, we get an average of 3% of an estate to probate a will, and we get 1% to settle the trust, means close it out. Like take just a $500,000 estate. If you have to probate and get 3%, that's $15,000. If it's a trust, you get 1%, it's $5,000. And the reason it's $15,000 to probate, but only $5,000 settle the trust, the $10,000 difference, there's the cost of going to court. It's a 5-figure item, and for a lot of people, it's a few $10,000 bills. We don't go into a client meeting with any agenda. It's very open-ended, because until you know the client, their family, their values, their likes and dislikes, a lot of social work has to be done before the legal work can be done. So once the social work is done and the client feels relaxed and comfortable, and you know them and their family and their wishes and their assets and their income, and you look at their current plan, will, trust, power of attorney, whatever they brought, things naturally unfold. And sometimes there are options and sometimes there aren't. So when there are options, you will lay out the options so the client can go home and think it over and see which of those options appeal to them. And sometimes there really is only one viable option. But still, the client has to go home and think about it, because this type of planning has to settle in. You know, we'd like to say, let it percolate. You know, let it settle in, see what feels right, and then come back, we'll talk about it more. Remember, we're in no hurry. So there are different strategies. I think one thing that we talked about this recently, the reason you go to a lawyer, an estate planner, to do an estate plan is because you really will learn what other people have done in the same circumstances. So you're dealing with somebody who's had thousands and thousands of experiences. That's why, you know, trying to do it online or trying to do it yourself, you know, you might get the paperwork, but you don't have the experiences. You don't know what people do and why. You don't know what the options are. So I like to say we relax our way into it.
We do, and I think giving them your book helps. It's another layer of understanding. They can go home, read the book, mark it up, come back in with more questions, so we know what's best for them.
And people can read at their own speed. So even if they don't get it because they can't absorb it while we're talking, they can certainly absorb it. A lot of clients come in and say, I really appreciate the book, and it really helped me understand things. So I think the main thing that we would want to impart to people is, don't be intimidated. You know, we're building a relationship, and relationships are built slowly. So you won't feel any discomfort or rush at all from us.
So I've had people come in who say, I got a will online. I'm going to fill it out myself. I have a power of attorney and a healthcare proxy. Can you notarize it? And I tell them, these are items that you really need to do with a lawyer, because the potential for problems down the line is great. Even a trust. Some people have come in with do-it-yourself trusts, and we know how complicated trusts are. So maybe talk about how important it is for people to consult with an attorney when dealing with these issues.
Well, I wouldn't want anybody to think that we're self-interested in advising them to come to a lawyer, because it's not the case. I think there's a great misapprehension on the part of the public that lawyers are expensive, and perhaps in some areas they are. But in our area, when you have an estate plan, invariably you save money or make money, or you save or make a lot more than it costs to do the plan. So it's actually a money maker. So it's really in the client's interest to find out these options, what it does for them, and where those savings and gains are. So I just want to show a copy of Elder Law Estate Planning, because as you can see, there's a lot to know before you do an estate plan. And as you told me, and it's very true, an incorrect estate plan can be extremely costly. And we have found regularly that an incorrect estate plan causes a lot more problems than it solves. I think once people understand the process and they're led through it in a very carefully and comfortably, they see the benefits themselves. I mean, there is a reason over 15,000 people have hired Ettinger Law Firm. And I'd like the opportunity for other people to find out how elder law estate planning can benefit them.
The most important thing is being informed. We say do your due diligence. When you're hiring any professional, I tell people, be it a lawyer, a doctor, a carpenter, a plumber, make sure that it's a good fit for you. And the way that we practice is unlike many other attorneys. The knowledge is the most important thing. They have to, as you said, they have to feel comfortable, they have to know what's right for you. So the book helps, and so do the seminars, and so does our approach to learning about our clients.
We should tell people how many people we turn away. Many people come to the office, we review their estate, and we review their documents, and we're satisfied with what we have. And we say, everything you have is in order. You don't really need any work.
So the estate planning process that we use is effective. We have people either come to our seminars or they watch your seminar online. Some people come in for referrals, based on referrals. And when we meet with people, we talk to them in depth about their families, their assets, what they're trying to accomplish. I think the most important thing that we impart to people is knowledge, because when you're making such an important decision, you need to know they have all the right tools, that it's a good fit for you. I always tell people, whatever professional you're picking, it has to be a good fit. We go over the reasons to choose us, the experience, the knowledge, the book that you wrote. This is helpful. This is a helpful tool because people get a chance to read it on their own. They get a chance to go through the pages. They get a chance to highlight. I've had many people comment on how great the book is. What's your reaction from people? I'm sure they love it.
Well, we use the book as a teaching tool because we want to build the client's confidence. And estate planning is about building the client's confidence, making sure that they understand what they're doing, why they're doing it, what it'll do for them. So they go forward into the future feeling secure that no matter what happens, they have a plan that'll cover that particular situation. So we make our recommendations, and then we tell the clients, these are the chapters that apply to you. 1 to 6, 20, 21, whatever it is, maybe an hour's worth of reading. Once you go home and read it, come back and we'll answer any questions you have about what you read. So we're building that confidence, that knowledge base, that depth. And when a client has all their questions answered, well, then they're ready to go forward because we've eliminated all the fear, intimidation, concerns, and now there's a different dynamic. We've noticed after the estate planning process is finished, clients experience a sense of relief. They very often say, we feel so much better, we feel so secure, and it may be also because at Ettinger Law Firm, when somebody signs with us, we don't say goodbye. You know, the standard in New York, and even around the country, is thank you very much. This concludes our representation of you in this matter. But we feel that's inadequate because you don't want to use the plan in a couple of weeks. You want to use it in 40, 50 years at a minimum. So who says it's going to work? So we track the plan. If there's a law change, we'll tell you. And we call you in for a free review every 3 years. Is this still what you want? Is there any changes in your health, your assets, your family, births, deaths, marriage, divorces? So the plan is not just designed to work when the client signs it. It's actually a plan for life. And we're building that relationship right through their lifetimes.